Hey folks, I'm Keith Stickley with the Stickley Law Firm here in downtown Hillsdale, Michigan. Today we're going to be having a conversation about plea deals. Now, if you or somebody that you care about has recently been charged with a crime, you may have heard that the prosecutor is trying to offer some kind of a plea deal. Today we're going to jump into plea deals, what they are, and how they can be used effectively. You might think you understand what a plea deal is, but think again. These agreements are not always what they seem. And if you or your attorney don't know the rules, you could be making a huge mistake in taking. Today, I'm going to go over 5 shocking truths about plea deals that could change everything about your case. So, truth number 1 about plea deals is that most cases end in a plea. But why? Why don't we have way more trials going on? Well, over 90% of cases today in Michigan end in some sort of a plea rather than a trial. And there's reasons for this. Some of the main reasons are that prosecutors want to avoid lengthy trials and courts need to keep cases moving. There is not an unlimited supply of resources at a prosecutor's office, and they can only do so much. And the thought is if by giving somebody the benefit of a bargain, they can keep the dockets moving, they can keep the cases moving so that things don't take forever. Now, think about it from a guilty client's perspective. Why beat a dead horse, right? There are some cases that are just bad. You don't have facts on your side, and it looks like it is just not going to end well. Well, and if a defendant knows that there's overwhelming evidence, there's a good chance that they can limit potentially the amount of dirty laundry that gets aired in a public courtroom. That's something that we see as a motivation for a lot of defendants that want to take a plea. And some prosecutors, particularly in drug crimes, are more concerned about people getting the resources they need than about just racking up convictions. Now, sadly, this isn't always the case, particularly in some of the areas that we practice, but sometimes it does happen. And when plea deals are given that reduce drug charges that are relatively easily provable because of the circumstances by a prosecutor get dropped down to a misdemeanor, or sometimes some form of a lesser charge that includes things like rehabilitation programs or maybe specialty courts, sobriety courts, or drug courts, it can be often really in the defendant's favor to go ahead and take advantage of that plea deal because it's really help that they need. But it's important to keep in mind, not every plea deal is a good deal. Some are rushed, they're unfair, they're based on weak evidence, and some of these offerings are really things that might seem like they're good on the face, but it's worth taking them to trial. The really hard part of the equation is knowing which is what. In other words, when is it time to fight and when is it time to negotiate? And that's where communication and trust with your attorney is so absolutely critical. And you got to ask them. You have to fairly ask that attorney. Say, hey, look, what do you really feel like my chances are in this situation? How strong is this evidence? Are victims going to potentially show up? Is the prosecutor, do they have strong evidence? Is there video evidence? Or is this something that we can potentially limit and mitigate the factors? What is my exposure to going to prison versus maybe doing local jail time or just probation if we take their plea? And those are things that all need to be taken into account. And a lot of times, cooler heads will prevail and a common sense solution will be reached between a criminal defense attorney and the prosecutor. And that is probably the largest contributing factor to why most cases do end up in some sort of a plea deal here in Michigan. Now, truth number 2 that you really need to know about plea deals, and that is that not all plea deals are the same. There are 3 main kinds of plea deals that we're going to be discussing today. And the first is what I consider basically the simple plea deal. And that is the stereotypical situation where, let's say, somebody is charged with a 1-year misdemeanor or a 5-year felony. And the prosecutor says, okay, look, if you plead to this lesser charge, if you admit to this lesser charge, then we will let that go forward and we will dismiss the bigger charge. And it's pretty common. That's probably the most common form of a plea deal. And sometimes it might be in the defendant's benefit, right? You're getting a benefit of the bargain. You're agreeing to not make the prosecutor jump through a million hoops by simply admitting what you actually did and acknowledging that it probably meets the requirements of a crime. In other words, that a crime was committed. But there's 2 other kinds of pleas that are really, really important. And if you haven't had this conversation with your attorney about it, or you're just going in to have a consultation with your attorney, you really need to ask about. And those 2 kinds of pleas are called a Killebrew plea and a Cobbs plea or Cobbs agreement. Now let's talk about the Killebrew plea first. So in Michigan, one of the main reasons that a defendant might want to engage in some sort of a plea deal is because they're going to be promised a lesser sentence. And a Killebrew plea is a kind of a plea between the prosecutor and their defense attorney and the defendant, okay, where the prosecutor says, okay, plea to this charge, and we will agree that your sentence will be X, okay, some amount of time, some amount of predetermined time. In other words, and I think we've talked about this in other videos about sentencing, so you might want to go back to our channel if you have further questions about it. In Michigan, we have, for felonies, we have indeterminate sentencing. You're sentenced to a range of time. And that range of time might be like 0 to 17 months, okay? So in other words, the judge, if your sentencing guidelines come back 0 to 17 months, the judge could give you 0 prison time, or they could give you 12 months jail time, or any time less than that, or they could send you to prison for 12 months up to 17 months. So in a Killebrew agreement, if the guidelines were 0 to 17, the prosecutor might say, okay, here's the deal. We will Killebrew, we will agree that there will be no upfront jail or no upfront prison. And the prosecutor and the defense attorney and their client will sign an agreement, sign a Killebrew agreement that will be presented to the court. Now, at sentencing, the judge will look at this agreement and say, okay, I see that there is an agreement between the prosecutor and the defendant to be sentenced in a certain way. Now, if the judge doesn't agree with the deal, sometimes a judge might think that a deal is too lenient. And by the way, if the judge is kind of cranky at the agreement that you've made with the prosecutor, your attorney's probably done a pretty good job. But if the judge doesn't agree and says, no, I cannot go along with this agreement, then most often you can withdraw your plea. In other words, the court will pretend like you never pled to the crime, and then the case can start over from the beginning. It's kind of like a safety valve. The third type of a plea that we're going to be talking about is a Cobbs agreement. Now, this is a little bit more rare in certain jurisdictions. In fact, unfortunately, there's some counties where judges absolutely refuse to do what's called a Cobbs agreement. And I think that's unfortunate, but I understand politically why a judge might be hesitant to do this. Let me explain. The judge, after hearing the plea, or really even prior to setting any sort of a sentence, the judge will agree to give a sentencing preview before you actually enter the plea. But the judge could still change their mind at sentencing. Let me explain that a little more clearly. Let's say a prosecutor will not agree to a Killebrew, but they tell you, well, let's ask the judge. Let's ask the judge for a Cobbs agreement to see if the judge will sentence you in a specific way. And you say, okay. Oftentimes these are on the record, sometimes they're back in chambers. But everybody might have a meeting, and the defense attorney might say, Judge, here's the deal. My guy is charged with larceny, felony larceny, okay, $1,000 for a $1,000 item. My guy agrees to pay restitution, but we are asking for a Cobbs agreement that will not give the guy, my client, any upfront jail. In other words, when you sentence him, we're asking you to give us a recommendation that you won't sentence him to jail. And a judge will sometimes make some preliminary inquiries into the case and give you a determination, a preview of what the judge might do. And the judge might say, if he's really paid the restitution, then yeah, I can see that. I can see that I might not give him any upfront jail. We'll just give him probation. That's called a Cobbs agreement. Then the sentencing date comes up. And at sentencing, the judge will have a PSI report, a pre-sentence investigation report prepared by the probation office. This lists a bunch of recommendations of how the judge should sentence somebody. Then the judge might review the report and would say on the record, there is a Cobbs agreement. I agree that it would be appropriate for me to just sentence him to no upfront jail or prison, just probation. The judge can withdraw a Cobbs agreement. And that's important to remember. Cobbs agreements can sometimes be a little bit tricky. It's super, super important. Super important. If you're doing a Killebrew or a Cobbs agreement, that your attorney asks up front, what is going to happen if the Killebrew or the Cobbs agreement falls through or the judge refuses to follow it? Will you be allowed to withdraw your plea and start the case over? And that is such a crucial, important piece of the puzzle, because you want to know, if this thing goes sideways, where do I stand? Where do I stand? Do I just have to take it and go to prison, or face a really harsh sentence? Or am I gonna have a chance to start from scratch and try and defend myself? So many defendants charged with crimes take these plea deals without understanding the risks, without knowing what's going to happen if the Killebrew or the Cobb agreements falls through. So always, always, always ask your attorney, what's going to happen if this deal falls apart? The third truth you really, really need to know when it comes to plea deals is what kind of plea is going to be entered. And I'm not talking about the kind of agreement, what the actual plea is going to be. That's what we're talking about. A no contest plea versus a guilty plea. So let's talk about what a no contest plea is and what an actual guilty plea is. All right. So a guilty plea is just that. You are going to admit the crime and accept responsibility. And the judge is going to put it on the record, and you're going to have to answer questions and give a narrative of what exactly you did, which constitutes the crime. And the judge is going to have to accept that plea. Then there's the no contest. Now, a no contest plea is somewhat the same as a guilty plea, okay? But you don't actually admit guilt on the record. You don't vocalize what you did. You don't tell a judge on the record what you did that made you guilty. But you're telling the court, I accept the punishment. I'm not going to make an admission, but I accept the punishment. And like I said before, it's important to keep in mind, a no contest plea is treated and sentenced just like a guilty. So let's talk about why somebody might choose a no contest plea. Well, the main reason that we see it happen a lot and that we might recommend it in certain circumstances for our clients is that it can help protect you in civil cases. Like if somebody wants to sue you later. You see, in a lot of civil cases, they will literally use testimony and admissions that were made on the record, and they will use them. They can literally grab the transcripts from the criminal case and they can use them in the civil case. And if no admissions were made in the criminal case, that testimony, those admissions cannot be introduced into your civil case. Now, sometimes there's other ways that really sharp, smart attorneys can get various confessions or information in that can harm you in a civil case, but it can become much more difficult. So that is something that sometimes you can do to help protect yourself in the future. Now, another reason somebody might want to enter a no contest plea is because sometimes people know that they broke the law, they committed a crime, but they might not remember the fine details that a judge might be looking for when it comes time for what's called the factual basis. Factual basis being, that's when you actually tell the judge on the record, this is what I did. I did A, B, C, and D. So let's imagine a scenario where somebody was maybe drinking and driving, and it's their third offense, so it's a felony. And they were so inebriated that they don't really remember leaving the road or leaving the bar or hitting the tree or another car. But they do know that they were intoxicated and driving, but the middle part is just fuzzy, and they want to take responsibility. And in order to do that, they have to, admit what happened. Well, by asking the court to accept it as a no contest plea, the judge can use basically the police report or some other finding of fact for the admission, and not have to have you vocalize. Now, why is that important? Well, some judges, when it comes to pleas, are very persnickety about the format and the detail that you can go into. And if a prosecutor offers you a plea deal, let's say it's a really good deal, it's going to limit the amount of time that you spend in jail, or greatly limit the amount of time you might have to spend in prison. You need the judge to accept the plea. You need to give the judge enough information that they feel comfortable in accepting the guilty plea. And if they don't accept it, you might be left with no other option but to take a losing case to trial. That could be terrible, because that could literally mean it's time that you have to spend in a cage. And we don't want that. So a no contest plea could potentially be a useful tool to help a judge accept a lesser plea without risk or without worry of the plea blowing up and then you not being able to take the benefit of the bargain. Now, it wouldn't be right if I didn't wrap up this point here by emphasizing just because you're entering a no contest plea does not mean that you're not guilty or there's less guilt. A judge will treat a no contest plea the exact same as a guilty plea for the purposes of sentence. Now, the fourth big truth that you need to know about plea deals is that you don't automatically lose your right to appeal what you think is an unfair sentence just because you entered a plea. And that is such a big myth. It's a misconception. We hear it all the time. A lot of times people are afraid to enter a guilty plea to a crime because they're afraid of what the judge might do to them, especially in certain jurisdictions where they have judges who have reputations for being hanging judges, if you will. In other words, judges who punish unfairly or go grossly over the guidelines for no seeming reason at all. And there are those nasty judges in the state of Michigan. They are. The truth of the matter is you can still appeal a sentence that you don't agree with, even if you entered a plea. Now, there's a couple of main reasons that this sometimes happens: prosecutor misconduct or judicial misconduct, or maybe you think that your lawyer screwed everything up and there's completely ineffective legal representation. That's kind of a difficult one because so many times in these pleas, the judge will ask the defendant time and time and time again, have you had a full, complete conversation with your attorney? Do you understand what's happening? At least the good judges who comply with the rules and such do. Or maybe there was a violation of your rights. These can find a reason that you still should have an appeal. But there are limits, and there's an important thing that you have to do. So when you are sentenced to a felony sentence here in Michigan, at sentencing, you are going to be handed a piece of paper, and they're going to give your attorney one too. And you're going to actually initial that you've received the paper, and it's what's called a notice of appellate rights. This is a critically important piece of paper if you think you've been done wrong at sentencing. Now, if you give this paper to the court at sentencing, you can still ask the Court of Appeals or whatever the next highest court is to review your case. Just because you enter a plea does not mean that you have no right to appeal a judge's decision regarding sentencing. This is called appellate rights. It's critically important, if you're not working with us, if you're working with any other law firm, that you ask your attorney about your appellate rights prior to sentencing. And they should explain how this works because it's very, very important. And the fifth truth that we're going to talk about is the secret reasons prosecutors offer plea deals. And the big hint here is it's not always because prosecutors have a strong case, even on a lower charge. Oftentimes, prosecutors start offering plea deals when they think maybe the evidence is weak and they fear losing a trial. Sometimes, and this is a big one that doesn't get talked about a lot, but I see this a lot. I really do see this a lot. The prosecutor might want to protect some informants or keep certain details of investigations out of a public record. I tend to see this a lot in drug cases where maybe they're trying to prosecute somebody for, let's say, delivery and manufacture of methamphetamine. And maybe there is a big drug ring bust, and they are getting information from confidential sources into both the investigator and the prosecutor's office. And the prosecutor knows that if the case goes to trial, the defense attorney, if they're decent, if they know what's going on, they know that the defense attorney might kind of expose or put on the public record certain confidential information that could hinder future investigations or future arrests, and they don't want that to happen. It might be a lot better, especially if the prosecutor sees a defendant as a smaller target, to give them a much reduced potential sentence or plea deal or plea agreement in exchange for not having to put out all this information and discovery on the record where it could potentially alert future targets of their investigation. Another big reason or secret that prosecutor offer plea deals is, well, like I said before, I think in point one, some of them are just completely overloaded with cases and they need to clear their docket. We are all only blessed with the same amount of hours in a day, and we have to keep the wheels of justice moving. And sometimes they just have to make a judgment call. It's in their best interest sometimes to go after big cases and not pursue little cases that don't really have a big impact on public safety, or maybe there's somewhat victimless crime, and they're like, hey, look, let's just move this thing through so it's one less thing that we have to worry. And another thing that we see very often as a reason that a prosecutor might offer a plea deal is that, well, they know that they might have a good case. They might have a very strong case. They might have a very good case that they could potentially take to trial and win. But they're concerned that a crucial witness or maybe even the victim will not be reliable on the stand, or that they might flake out and not show up to court on the day of trial. And that is probably one of the biggest factors that can really hinder the prosecution of a defendant, is when a key witness, a star witness, or maybe even the victim uh, decides not to show up or decides to stop cooperating with the prosecutor. We see this a lot in various assaultive crimes that are relatively minor in nature and occur between maybe family members or friends or business associates, people who maybe something happened, maybe an incident happened, but they kind of got over it, right? They don't really want to see the other person get in trouble. So they just stop cooperating with the prosecutor. And the prosecutor might go, oh my gosh, well, I don't know what to do. We can't get this guy on felony assault or whatever, but I want to get him on something, right? I want to get him on probation and make sure he's not a threat to society. So let's offer him a misdemeanor A, B, A and B, assault and battery. That's something that happens time and time again. An extremely popular reason for throwing out plea deals. Something that really stinks that we sometimes see happen in courts is we see people taking plea deals when we know that the prosecutor is only offering the plea deal because they don't have a very good case to begin with, and the case can probably be beat. But the person takes a plea deal, and the prosecutor is like, "Whew, I'm relieved. At least I get something on this guy." And those are unfortunate. And that's really the situation that you want to talk with your attorney, because you don't want to be that guy. You don't want to be the guy who could have won a case, and your attorney is very confident that you could have won a case, but you cop to a lesser charge, and maybe it cost you some time in a cage or quite a bit of money. And it's important that you work with an attorney, be it at our law firm or any other firm, but that you feel that you can trust and have decent communication with. A good attorney is going to give you the cold hard truth and present to you all the possible options, the good ones and the bad ones. And it's you or the person being charged with a crime that's going to have to be the one who makes the decision after taking into account the attorney's experience and advice of what path you're going to go on. Are you going to accept a plea, or are you going to take it all the way? And that can be a lot to digest. So now that we've talked about the 5 big truths about plea deals, I don't want you to make the mistake of taking a plea deal without really knowing all your options. And if you or somebody that you care about is facing criminal charges here in Michigan, call my office at the Stickley Law Firm and we'll talk about your case before you make a decision that could really change your life for the better or the worse. It's important to explore all your options. If you found this content helpful, do us a big favor. Like, subscribe, and follow our channel for more legal insights that can protect you and those you care about. We'll be here for you when you need us.